Welcome back to the PI Show, viewers. Now it's time for Kathy's mailbag. Good evening, Kathy.
Good evening, Nunzio. Alice, how are you?
Kathy.
Good evening, viewers.
What do you think of the air carriers liability segments?
I thought it was actually really interesting, quite informative. I find it really restrictive, though, for plaintiffs, which isn't good when they're on the airplanes. But I just hope that everyone keeps safe and doesn't get injured on planes.
Look, it's a very technical area and restrictive in a way, but look, that's what we're stuck with now, so we've got to deal with it. So.
But I think it was really good that you alluded to the 2-year strict time frame and that all viewers who ever incur these types of injuries or accidents, that they should actually get advice immediately.
That's crucial.
Yeah. It is. But anyway, we've got to get on to our questions because it is time for the questions. First one comes from Celia in Keilor. She writes, Dear PI Show, last year I was travelling on an international flight from the USA to Australia. Before the plane took off, it jolted whilst on the runway. During the flight, the overhead luggage compartment above me fell open and the luggage fell straight on top of me. I have sustained injuries to my neck and head and an incident report was filled out. Will I be able to claim for my injuries? Now, Alice, Nuns, I'm going to start with you on this because it's quite... I mean, we were just touching base on it before, so what advice can you provide Celia?
Look, Celia arguably does have a viable claim because, as we said, in the last couple of segments, you need to prove that it was an accident and that it was unusual, unexpected, and outside, I suppose, the external actions of Celia. And I think, something to that effect could arguably be a case for her. And again, she's got to make sure she makes the claim within the 2 years. What do you think, Alice?
She's only got a year to go. I agree, Nuns. I think that Celia would have a claim. It seems like a very unusual set of circumstances, particularly seeing as the overhead compartment's fallen open without any warning. And say, had she been fiddling with it and the luggage fell on top of her, that would be a different thing. She might have a few issues making a claim in those circumstances. But from what she's telling us, it would definitely be worth looking into.
I find it quite interesting that the plane actually jolted on the run, no, not that it jolted on the runway, but something like that would happen.
That's right.
Because you would think it'd be a little bit more secure. So.
Well, you've just answered our own question. Well, the fact that was peculiar suggests there could be an accident. I think that probably proves that she may have a case. So
that's right.
I think Celia should definitely seek some advice.
Of course. Definitely. Well, we hope that's helped you, Celia. Moving on to question number 2 tonight. Dear PI Show, I would like to know if I can raise a medical negligence claim. 2 months ago, I broke my middle finger in my dog's collar. I attended the hospital, who ultimately operated on my finger to reattach the tendons and insert 2 screws. When I was in recovery, the surgeon advised that the reason I was in so much pain was because they had put one of the screws in the wrong place. An X-ray shows that there were 3 pins instead of the 2. One was parallel to the bone and not even in the bone. I may need another surgery to rectify this. Do I have a claim? And this is from Lauren in Dandenong. Alice, what can you advise Lauren?
What I can tell Lauren, Kathy, straight away is that with medical negligence things, the best way to think about your claim is that there's 2 things you need to prove. One is I have a bad injury, and 2 is it's someone else's fault. And MedNeg is quite complicated, mainly because she will have to get other surgeons on her side to say, well, that's not the way I would have done the hand surgery. The Wrongs Act, which governs medical negligence claims, does require that doctors in the same field need to comment upon the treatment that you've had and tell us, or tell the court as well, whether or not that treatment has actually fallen below an accepted standard of care. So we would need to know a little bit more about this case in terms of what operation exactly was underwent and exactly what pins were inserted. We'd need to look at the medical records and things like that. On the face of it, Nuns, I think that sounds like there's something there, but...
Yeah, there could. You mentioned 2 things, obviously the fault and the injury.
That's
so
right.
What does she need to prove with regard to the injury?
With regard to the injury, she would also need to show that she's over that 5% threshold, very similar to public liability claims. She will need to show she's got a permanent and stable injury. So it looks like Lauren would also have to undergo further surgery to her hand that is being suggested, and so you know what her end point is, because unfortunately the law needs to know, once you've had a chance to try and improve yourself, what your end position is and whether or not you have a permanent injury as a result of what's happened.
And can she claim all these medical expenses, because she's going through a lot by the sounds of it?
That's right, she certainly can. If she can prove fault, she can claim medical expenses, not only past but also into the future.
Out of curiosity, Alice, does it matter if there's only one type of surgery that can be performed for for that injury, if that makes sense, because sometimes there are more than one surgery and
yes,
the surgeon
that's right.
will elect
and whether or
the
not
type.
it's the right
Yes,
choice. Yeah, that's an interesting question, Kathy. It doesn't matter as much as it makes it perhaps a little bit more specific.
Okay.
So if there was only one surgery she could have for her hand, you'd then need to look at how it was performed, what materials were used. Obviously, it's really difficult because we're never in the operating theatre with the surgeon, so we don't know exactly what's happened.
We are lawyers, Alice.
After all, I think we
Not
should stay
surgeons.
right out of it. But yeah, look, Lauren will need to give us very specific instructions on exactly what happened and, you know, and what she sees on the x-rays and things like that.
Okay, so she should definitely seek legal advice for that.
Yeah, I would think so.
Okay, great. Well, we hope that's helped. Moving on to our third question. DPI show. I work for a car rental company at Melbourne Airport and was injured while working 2 years ago. The injury involved me catching my right knee on a bent car number plate so that my knee bent right back and caused a tear in my medial meniscus. I am still on work cover payments and have had surgery on my knee and completed physio sessions and 3 months rehab at a local gym. I am still on medication and we're taking a lot of medication from the looks of things here. Any help or advice would be great. And this is from Rob in Williamstown. Nuns, can you start us off with this? I mean, work cover entitlements.
Yeah, well, obviously, look, Rob's already commenced a work cover claim, so he's getting all his medical expenses, and from what I understand, obviously, his weekly payments would be getting paid by the insurer. I suppose the next phase is his no-fault entitlements, which is obviously Section 98. Impairment claims.
Lump sum impairment benefit
and then,
claims.
by an extension of that, the big one is probably the common law claim. And usually have at least 18 months after the date of injury to commence that. And so, look, Rob could probably start that now if, if he sought the advice of a lawyer, and they could, give him, the directions from there.
That's
Absolutely.
right. And a lawyer will help him make the choice as to whether or not he has his impairment payment, which takes a little less time than a serious injury claim, and you can get a bit of money in your pocket to get you through, or whether or not it's worth just going straight for the common law because it's the larger claim, and that'll depend upon the extent of his injury
That's
as well.
right. But I will also just touch on this question because from what Rob says here, that he's been on payments for about 2 years. And Rob, what you'll need to know is that there's an automatic termination at the 130-week mark from work cover when you can't do your pre-injury duties. What happens is at that time the insurer will actually terminate your rights.
On what basis?
It's a section that covers that if you're entitled to have 130 weeks of weekly payments, provided that you are unfit for duties for your pre-injury duties. Now, if going forward after that 130 week, the test is different that you have to satisfy, you basically have to show that you can't perform any duties in any employment in the open job market. So that could literally be a changing job. So these are the things why you need to seek legal advice to see which claim would be better for you.
Yep.
So, well, anyway, seek legal advice and hopefully someone can help you with that. But it is that time of the show where we've come to, we've got no more time for questions. We would like to remind viewers to keep watching and also to keep writing us questions. Our email address is info@thepishow.com and our website is www.thepishow.com. And thank you so much for your informative answers
Kathy.
tonight.
Thanks, Alice.
Thank you for having
Good
us.
night.